This is a very short speech connection with the Insolvency Bankruptcy Code, particularly about the scope of Section 19, which is one of the very frequently referred to provisions in the Insolvency and Bankruptcy Code. Section 19 was intended for the purpose of ensuring that the suspended directors and the persons who were in the management of the corporate debtor prior to the commencement of the insolvency resolution process render such cooperation and assistance as may be necessary for the purpose of the CIRP process, that is Corporate Insolvency Resolution Process, to happen smoothly and on time, because under IBC everything is time bound. Section 19 is requiring the suspended directors to provide certain assistance and cooperation. So for your information, if you read Section 19, it's very simple provision. Subsection 1 is the most important of it. It says all the personnel of the corporate debtor, the promoters, or any other person associated with the management of the corporate debtor shall extend all assistance and cooperation to the resolution professional as may be required by him in managing the affairs of the corporate debtor. So, in Section 19, specifically, there is a provision which binds the promoters, directors, and persons in the management to provide assistance. Here is a case which was recently decided on the 19th October 2022 by the NCLT, wherein the applicants were the persons who have provided some services to the company, and obviously they were related parties within the definition of the term related party as given under the Insolvency Bankruptcy Code. And it appears that the resolution professional has assured these people, the gentlemen who have provided certain services to the corporate debtor undergoing the corporate insolvency resolution process, that they will be remunerated. However, a provision of the code, that is Insolvency Bankruptcy Code, Section 28, requires approval of the Committee of Creditors for the purpose of availing related party transactions. Obviously, these people were directors and key managerial personnel, therefore they will come under the category of related parties, and the corporate debtor has availed their services for probably a couple of months, and their claim for remunerating them for this period was rejected by the Committee of Creditors. And from the facts as narrated in the order, we understand that the RP has assured them, the resolution professional has assured them they'll get remuneration, number one. Number two, otherwise why would he place the remuneration for approval before the Committee of Creditors again and again? And it appears from the reply that the remuneration that they have asked is exorbitant and probably higher than what they were drawing prior to the commencement of the CAR. We are not on those decision and observations and all, because we do not have complete details of the provisions and the facts. Going by the provisions alone, I just wanted to address. Directors are going to be suspended directors. The moment the insolvency resolution commences, directors are going to be suspended directors automatically. Now, we have to also understand that the commencement of CIRP, that is Corporate Insolvency Resolution Process, does not in any way discharge the officers, employees, and workmen, as is the case when an order of liquidation is passed under Section 33, subsection 7. Therefore, employees will continue to be employees, workmen will continue to be workmen, officers will continue to be officers, unless and until there is a reason for terminating their services, probably because the corporate debtor is not a going concern or in some other circumstances. Therefore, there is no bar in continuing to retain the services of certain gentlemen as officers during the CARP, and therefore it will include in the CARP cost. Secondly, section 19, as I read it out, does not expect any person who, including a suspended director or promoter, to be in the employment and offer their services, which probably in employment a person would be doing. Even a managing director or a director in the whole time employment is an employee. Employee is a broader word which will encompass within it the officers, employees, workmen, and everybody employed by the company. And in this case, probably the resolution professional has availed their services for a few months and they were expecting remuneration, and section 19 is not the appropriate provision to reject a remuneration expectation of a person who has been employed to provide certain services. Under section 19, the promoters, directors, suspended directors, and others who are in the management of the company, that is corporate debtor, which is undergoing the corporate insolvency resolution process, is expected to provide cooperation assistance. That does not, in my humble opinion, respectful opinion, does not encompass within it an employment of somebody to do some services. Secondly, the NCLT has also referred to commercial wisdom. Commercial wisdom theory is, yes, it has been very repeatedly upheld by the highest court of this country. But in employing somebody for a few months for some remuneration, rejecting it on the ground that they are a related party and therefore the transaction is a related party transaction and they are asking for an exorbitant remuneration and the COC's approval is prerequisite for the same, and therefore the COC, that is Committee of Creditors, has rejected it. So all depends on facts and what representation was made. But to employ a person in the ordinary course of business of the corporate debtor and paying some remuneration, reasonable remuneration I will add here, I don't think there is any commercial wisdom here. It is the resolution professional is required to manage the affairs of the corporate debtor. He is ordained to do that under the statute, and he feels that a person is required to be employed for a few months for the purpose of carrying on the business of the corporate debtor, so that the resolution process is enabled and it fructifies. Therefore, we cannot, in my humble opinion, invoke the commercial wisdom theory for each and everything. COC has not approved it, is the simple thing. COC has not approved. For whatever reasons, that is best known to them. That doesn't mean in commercial wisdom, the COC is taking a decision of this nature also. I think we are probably expanding the theory of commercial wisdom to everything that COC does. I don't think it was the intention of the decision of the various courts as well as the Supreme Court of India to bring commercial wisdom to apply to everything at the drop of a hat. Therefore, there are two things which as outcome I want to tell. Number one, employing somebody is different from requiring that person to provide assistance and cooperation. It does not mean that a person must be employed and you will not remunerate them to any reasonable remuneration that they may be entitled to. Employing somebody to provide services for a particular period is absolutely not within the scope of section 19 to where it is required the promoters, directors, and persons in the management are required to provide cooperation and assistance. Number two, rejecting the remuneration application or demand or claim of a person who has served the company, the corporate debtor, for a few months because COC has its powers under the code does not mean COC is rejecting it within the meaning of the commercial wisdom theory. That's all. If you have a difference of opinion, so it's okay. You can always kindly feel free to share the same so that the understanding of section 19 is properly brought out. Thank you for listening to me for these few minutes. And I always welcome all of you to subscribe to my channel. Also forward it to others who may be interested in the subject if you know them. And also feel free to share your OCS, that is observations, comments and suggestions